Committee will come to order. This is a joint subcommittee hearing of both the Subcommittee on Oversight and Government Reform for TARP, Financial Services and Bailouts of Public and Private Programs, and the Subcommittee on Financial Services on Capital Markets and Government-Sponsored Enterprises. This hearing is entitled the Jobs Act, Importance of Prompt Implementation for Entrepreneurs, Capital Formation, and Job Creation. We have a tradition on the Oversight and Government Reform Committee to read our mission statement, our committee's mission statement. We exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the bureaucracy. This is the mission statement of the Oversight and Government Reform Committee. Because it's a joint subcommittee, we are happy to be with my colleague Scott and Mike and Maxine for this hearing today. I will now recognize myself for 5 minutes for the purposes of an opening statement. Current economic and jobs numbers remind us that the U.S. labor market continues to face unprecedented challenges. The unemployment rate has remained over 5% for 43 consecutive months, and nearly 24 million Americans are unemployed or underemployed. To effectively address our sluggish economic recovery, the House Oversight and Government Reform Committee and the Financial Services Committees have identified outdated securities regulations that limit job growth and access to capital, which is the lifeblood of our economy. Our efforts come together in an overwhelmingly bipartisan bill known as the Jobs Act, which the President signed into law this April. Today's joint subcommittee hearing represents continued efforts by both subcommittees to examine obstacles faced by entrepreneurs and small businesses and allow the Jobs Act to advance capital formation and facilitate public offerings. Supported by every member of both subcommittees, which is, let's just say, rare in this Congress, the Jobs Act has clear-cut intentions, and that is to revitalize the creation and growth of American small businesses. But while Congress's intentions may be clearly stated in the legislation, several sections provide the SEC authority to promulgate rules and regulations in a timely fashion. Unfortunately, the SEC chairman has already abandoned her commitment to finish the Act's first deadline and most straightforward provision, which is the lifting of the ban on general solicitation to accredited investors, which is Title II of the bill. And although the SEC chairman has compared the recent regulatory delays of the Jobs Act to the regulatory delays of Dodd-Frank, the truth is that they are dramatically different. They're worlds apart. Dodd-Frank mandates 95 rulemakings, many of which concern issues that are foreign to the Securities and Exchange Commission, in particular extractive industries and conflict minerals. In comparison, the Jobs Act simply mandates reforms that lie at the core of the Commission's expertise. So while Dodd-Frank rules require careful and deliberate speed, the Jobs Act should be seen as a walk in the park for the SEC. Having authored the original crowdfunding title of the Jobs Act, I'm concerned that the SEC's habitual 11th-hour decisions defy the bipartisan foundation of the entire legislation and may even stymie capital formation for small businesses altogether. This would be a tragedy for a bill whose only motive is to promote capital formation and unlock opportunities and information for investors and job creators. Currently, there is a real chance that our entrepreneurs and innovators could lose their competitive advantage simply due to outdated securities laws. However, after recognizing the efforts of Chairman Garrett, Ranking Member Quigley, and Waters to modernize our nation's securities laws, I am confident that our committees can continue to promote policies that ensure the United States never becomes complacent about its environment for startups and innovation. And I believe that the Jobs Act is our first step in the right direction, but only if it's implemented correctly. I thank our witnesses for attending today's hearings. Each of them is respected in the field of capital formation and securities laws, or in particular the creation of granola. And so we are grateful for the witnesses today. And with that, I'd like to yield the balance of my time to the full committee chair of the Oversight and Government Reform Committee, Mr. Eisen.
Thank you, Mr. Chairman. My goal in a short opening statement is, first of all, to thank you for your leadership on this. This is a joint committee hearing. It's a joint committee hearing for the reason that is pretty clear. Financial services and oversight have both worked tirelessly to try to be an active part of job creation. Our committee and the Financial Services Committee both were involved in Dodd-Frank, and both were involved in the Jobs Act. Your earlier statement is exactly right. Dodd-Frank has been put in front of the Jobs Act. The SEC chairwoman, in fairness, got Dodd-Frank first, but in fact, since Congress got Dodd-Frank wrong, she's having a difficult time implementing it. It is our opinion, and I believe today's hearing will show, that the creation of private sector jobs should come before the creation of new bureaucratic organizations, no matter how well-meaning, in Washington. More importantly, it is clear that many of the aspects of the Job Act are long overdue, and if implemented, would have given a signal to the private sector that business was now again a priority. I commend the President for his quick signing of it, his ceremony, his statements. But unfortunately, Rose Garden ceremonies do not take the place of actual implementation or allowing the private sector to create jobs. In closing, Mr. Chairman, I believe we understand that if government grows, it may create private sector jobs by spending taxpayers' dollars, but only through private sector job growth will tax revenue close the deficit we already have. And with that, I thank the Chairman and yield back.
Thank you, Mr. Chairman. And with that, I will yield to the ranking member, the gentleman from Illinois, Mr. Quigley, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Chairman McHenry and Chairman Garrett, for holding today's hearing on implementation of the Jobs Act. I'm also pleased to be joined by my colleagues on the Financial Services Committee Capital Markets Subcommittee, including Congressman Waters, the ranking member. This is this subcommittee's third hearing on the implementation of the Jobs Act. As we know, the Jobs Act was passed with bipartisan support and signed into law by President Obama on April 5, 2012. The Act amends Federal securities laws and regulations to make it easier for small businesses and startups to raise capital. Under Title III of the Jobs Act, for example, startups will be able to raise capital through crowdfunding. This is a big step forward for innovation and job creation in this country, and I commend the President and Chairman McHenry for working together on this issue. I am just as eager as my colleagues for the SEC to meet the aggressive rulemaking deadlines set in the Jobs Act. I am also eager for the SEC to finish its rulemaking under the Dodd-Frank Wall Street Reform and Consumer Protection Act, which was passed by Congress back in 2010. The Dodd-Frank Act, once fully implemented, will roll back the perverse incentives that cause financial firms to become too big to fail. It establishes the stronger prudential regulation, closing many of the loopholes that allowed Wall Street to engage in excessive risk-taking. Especially pertinent to the SEC, Dodd-Frank takes steps to eliminate serious conflicts of interest at credit rating agencies. Their inflated ratings of poorly underwritten mortgage-backed securities directly contributed to the financial crisis. I believe it is important that the SEC implement the provisions of both the Jobs Act and the Dodd-Frank Act in a timely manner. However, it is also important that implementation is not rushed and that the SEC gives appropriate consideration to the impact on investor protection. Rushed implementation of the Jobs Act could result in greater risk of fraud and harm to investors, and that would ultimately defeat the Act's intended purpose of increasing access to capital for business. In the long term, investors must have confidence in the integrity of U.S. capital markets, and that requires SEC rules and enforcement to prevent fraud from corrupting the new methods of raising capital. In June, the Oversight Committee held a two-part hearing on implementation of the Jobs Act. As I said at that hearing, just as clean water standards keep our water safe to drink, financial regulations protect us against unsafe financial products. The SEC has a dual mission to facilitate capital formation and to protect investors, and I believe that those must be equal priorities going forward. There is also no reason that the Jobs Act should be prioritized in front of the pending Dodd-Frank rulemakings. The same standards should apply equally to all of SEC's rulemakings that are required by law. Rushed, haphazard implementation of either act is unacceptable. And so while I urge the SEC to move forward expeditiously, I also urge the Commission to ensure both of its important missions are met. Thank you, Mr. Chairman, and I yield back.
I thank the ranking member, and I will now yield 5 minutes to the subcommittee chairman on capital markets, Mr. Garrett, my good friend and wise friend.
Thank you, Mr. Chairman. I appreciate you and your staff for your collaboration with the Capital Markets Subcommittee on this very important hearing today. And I think it is that having this hearing as a joint subcommittee between two authorizing committees should show both the SEC and the American public just how much of an important priority this issue is. You know, I likewise was dismayed recently to learn that the SEC, after missing its initial 60-day requirement for implementation of the general solicitation part of the bill, had again delayed implementation. And this was even after the staff had proposed moving forward with the interim final rule. You know, this type of delay on what is really a pretty simple, straightforward requirement from Congress is really unacceptable. The rulemaking process is not setting up a regulatory framework for a multi-trillion-dollar derivatives market. It is, however, on a topic that has been around for a long time. It's well known by the SEC and by market participants. This is so extremely disturbing, and I expect and hope that the SEC to move forward with finalizing this rule in the near future. You know, earlier this year, Congress passed the Jobs Act. This legislation would ensure that overburdensome regulation does not strangle innovation, job creation. Specifically, the Jobs Act would ease the burden on capital formation on entrepreneurs and growth companies. In addition, the legislation would provide a larger pool of investors with the access to information and investment options. So with venture capital fundraising stagnant now in this country, and the initial public offerings, IPOs market basically closed off, innovative startup companies who cannot access the capital markets they need to grow have been forced to do what? To delay research on medical technology, scientific, technological breakthroughs. That has hurt everyone, the economy, our global competitiveness. You know, developing medical cures to help people live longer, healthier lives requires capital. Developing technology to improve the speed of communication requires capital. Developing alternative energy technologies to reduce our dependence on fossil fuels requires capital. So the implementation, then, of the Jobs Act will provide these startup companies with a cost-effective means to start up capital and keep the country at the forefront of medical and scientific and technological breakthroughs. So with our nation still struggling with persistent high unemployment, it is essential, Mr. Chairman, and a bipartisan Jobs Act implementation becomes a high priority for the SEC and be done in the near future. And with that, I yield now to the gentleman from Alabama, Chairman of the full Financial Services Committee.
I thank Chairman Garrett and Chairman McHenry for holding this joint subcommittee hearing to review the implications of the Job Act. The Job Act was a victory for job creation and for job creation in small businesses. And let's not turn this victory into an empty one with regulatory red tape that stifles innovation, economic growth, and job creation as intended by this bill. As Chairman of the Financial Services Committee, I'm proud that the Jobs Act comprised of 6 pieces of legislation that originated in our committee and passed our committee with overwhelming bipartisan support. The Jobs Act is proof that when we put our minds together, Republicans and Democrats can work together, find common ground, and help small businesses, which are the growth engine of our economy. In previous economic recoveries, nearly 65% of new jobs were created by small businesses. That's not the case today, however. What we're seeing now is almost all job growth, such as it is, comes from small corporations. Small businesses are not growing for 2 reasons. Owners and entrepreneurs tell us that the first reason is excessive regulation, almost all of it coming from Washington. A second is lack of capital. When these regulations consume too much of our time, energy, and finances, capital is even more critical. The Job Act removes some of the unnecessary and outdated Depression-era job barriers to capital formation so entrepreneurs have more freedom to access capital, hire workers, and grow their businesses. Unfortunately, the SEC has already missed 3 JOB Act deadlines, and we're here today to discuss how important prompt implementation of the JOBS Act is to our economic recovery. The JOBS Act was a positive step taken by Congress and the administration to promote capital formation. It should be implemented by the SEC without further delay. With each job report, it becomes more urgent. American innovation and job creation must not be stifled by slow-moving government bureaucracy. And at this time, Subcommittee Chairman McHenry and Garrett, I would like to introduce some of the younger members to a former colleague of ours, Congressman Chip Pickering, who's on the first row. Would you stand up, Chip? Chip was Trent Lott's senior staffer and served in this body with distinction for several years, and I'm just sorry that some of the younger members didn't have an opportunity to serve with you, Chip. And we welcome you back to Congress, where you're so well thought of. Thank you, Chairman McHenry and Garrett.
Thank you, Mr. Chairman. We'll now recognize the ranking member of the Capital Markets Subcommittee, Ms. Waters of California.
Thank you very much. Normally, we start out our testimony by thanking the chair for holding a hearing. I won't be doing that this morning because I basically believe that this hearing is not necessary. I think that what we're witnessing is what gets in the way of bipartisan efforts. As a matter of fact, I think each of our members this morning have talked about how we cooperated to get the jobs bill passed, and we did. I reluctantly supported the act with the hope that it would help facilitate capital formation and create jobs. But I think this kind of attack on the SEC and the kind of accusations that are being made does not help us to foster bipartisan support for other efforts. I expressed some concerns about particular provisions in the Act, including the elimination of the wall separating investment banking from research, the expansive definition of emerging growth companies, and the increase in exemptions for provisions put into place by Sarbanes-Oxley and Dodd-Frank. I understand that today we're going to focus on some aspects of the JOBS Act that require SEC rulemaking before they can become effective. Some of my colleagues on the other side of the aisle have criticized the Commission for not just rushing through the process and putting a finalized rule into place before any public comment, apparently being upset that the SEC missed a deadline for a rule that was supposed to come out in July of 2012. I guess I would have more sympathy for concerns if I didn't also see a push to delay other rulemaking by the SEC, because while there are complaints about slowed rulemaking on a provision that would relax industry regulations, what I also find is there have been attempts to delay by passing legislation to delay any derivatives rulemakings for 2 years, asking regulators to repropose the Volcker rule, which was coincidentally also due in July, and trying to bog the SEC down in additional and onerous cost-benefit requirements while not supporting an increase in their budget. Now, again, I voted for the JOBS Act, and I want to see it get implemented. But complaints about the slow pace of rulemakings under the Act are simply unreasonable given these facts that I've highlighted. I am pleased that the SEC is seeking public comment on the proposed rule eliminating the ban on general solicitation and advertising under Title II of the JOBS Act. I had an amendment to that title which required that issuers of securities using this exemption take reasonable steps to verify that the purchasers of the securities were in fact accredited investors or individuals or entities that are supposedly sophisticated and not in need of additional investor protections. Given that this general solicitation ban has been around for decades and given that many stockholder perspectives on how to implement my amendment, it's appropriate that the public have the opportunity to comment on this provision. After considering the SEC proposal, I'm disappointed that They didn't require more robust verification procedures on behalf of issuers, and the Commission also should have considered the many suggestions offered by investor advocates and other stakeholders for additional measures that would decrease fraud in these expanded offerings. I want to make sure that as the SEC implements this provision, they are putting equal focus on all facts of their mission, including not just facilitating capital formation, but also protecting investors and maintaining market integrity. I hope to explore that with our other witnesses here today, and I yield back. Well, I will yield time to the gentleman from Connecticut.
I thank the ranking member, and I just want to add my observations. I'll tell you, in a moment of a hall of mirrors, this is truly a hall of mirrors. I've been listening since the Dodd-Frank passage to Republicans complain constantly, daily, weekly, monthly, that we should delay the implementation of the regulations that are there to keep America safe. We should delay, we should reverse. And now here we are saying at the SEC, in language, frankly, which is not promotive of the kind of comity we would have on Capitol Hill, saying that the SEC should move faster. I heard the chairman of this committee say that this should be a walk in the park. At the core of what we are talking about is protecting American investors from risky securities. I supported the Jobs Act. I worked very hard on the Jobs Act, but we are talking about preventing not just those investors, but the integrity of our critical capital markets. The chairman of the Government Reform Committee said we should put the creation of new jobs ahead of creating new regulations. That's actually a novel idea. The military, when something goes wrong, they do something called a stand down, where they figure out what went wrong and how to proceed with prudence and deliberation. The private sector, whether it's New Coke or Gibson Greetings, when they make a mistake, they stand back and they say, how can we avoid that happening again? We should do this, but we should do it with care and deliberation and not worshiping at the altar of deregulation.
Would the gentleman yield?
I'm out of time.
Well, comedy is a little different than comedy. So at this point, I'll just say that members will have 7 days to submit opening statements. For the record, we'll now recognize our first panel. I had a request from the chair of the Financial Services Committee to recognize and introduce Naval Ravikant. And with that, I'll recognize Mr. Backus to do so.
Thank you, Chairman McHenry, for allowing me to introduce my friend. I first met Naval before the House considered H.R. 2440, which became Title II of the Jobs Act. It was refreshing to hear from someone who had such passion for helping companies access capital they need to grow and create jobs. In fact, he has been the catalyst for several Internet companies which are now household words. He was a strong supporter of H.R. 2940 and H.R. 2930, your crowdfunding bill, Subcommittee Chair, in the House, and was instrumental in getting the Senate to act on the Job Act, which, as we know, is not an easy thing to do. Using technology such as Twitter, Naval, and AngelList put together a letter of support for the House bill that contains signatures from over 5,000 investors, entrepreneurs, and small businesses. Without Naval's support, we probably wouldn't be here discussing the implementation of the Jobs Act. And also, a fascinating thing to do, visited one of the sites which is a crucible for new Internet companies in San Francisco, and saw really a building full of young entrepreneurs. And they had video games, they had basketball court, they were watching sports, and they were also creating new companies. And several of them had been with Google, eBay, and other companies, and were part of the formation of other companies. And I didn't see any ties. I had a tie on when I first got there, and I took it off fairly quickly. But those are the job creators, and as we all know, our identity is really not in home ownership. It's in our occupation or our job. And without a job, it really denies us of a part of who we are and our identity. So I thank you, Naval, and I thank Congressman Pickering for your help with senators, his former staffer for the Commerce Committee or senior staff. Thank you. Thank you.
Thank you, Mr. Chairman. And in the interest of time, I'll introduce the rest of the panel. Mr. Robert B. Thompson is the Peter B. Weidenbrook Junior Professor of Business Law at Georgetown University Law Center. Mr. Jeffrey Van Winkle is the Treasurer of the National Small Business Association and a partner at Clark Hill. Ms. Allison Bailey Veracruz is the founder of 18 Rabbits, a small business that makes granola and granola bars, and from what I hear, they're delicious. Mr. Rory Eakin is the founder and chief operating officer of Circle Up, which is a form of crowdfunding, a wonderful website, both with AngelList and with Circle Up. It's been fascinating to see what you all are doing to link up innovators and capital. And with that, it is the policy of the Oversight and Government Reform Committee that all witnesses be sworn before they testify. So if you'll please rise and raise your right hands. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Let the record reflect that the witnesses answered in the affirmative, and they're now seated. So in order to allow for time for discussion, if you could summarize your opening statement, keep it to 5 minutes. We have a light system. Green means go, obviously. Yellow means hurry up and finish, and red means stop. So with that, we'll now begin with Mr. Eakin for 5 minutes.
Mr. Chairman, ranking members, distinguished members of the committee, thank you for the honor of appearing before the Joint Committee today and for the opportunity to speak on an issue of critical importance to the American economy. I'm the founder of Circle Up, a small business which supports other small businesses raising growth capital from accredited investors through the Reg D 506 exemption. Circle Up is a private investment platform that focuses on businesses outside of the technology sector, providing growth capital for consumer brands and products and retail companies through a network of accredited investors. My partner and I were inspired to found Circle Up because we saw a gap in the market, namely established high-growth businesses struggling to find affordable capital and a network of investors eager to fuel their growth. They needed a simpler, more accessible way to come together. Circle Up provides a platform to do just that. America is a country full of ideas and entrepreneurs pursuing their dreams. Over the last 2 decades, small and new businesses have been responsible for creating 2 out of every 3 net new jobs. And today, the country's 28 million small firms employ 60 million workers, fully half the private sector workforce. Investment capital is the oxygen on which young businesses survive. And today, investment capital market remains on a slow path to recovery. Bank lending, venture capital, and angel investing all remain below their pre-2008 levels, 13% below in the case of angel investment. Beyond these broad statistics are the Americans, small businesses, and investors currently limited by the ban on general solicitation. We see these companies every day at Circle Up. There's Kim Walls, the founder and CEO of Epicential, a skincare company in Los Angeles. Kim founded her company in 2009 to bring baby-safe, all-natural skincare products to market. After extensive product development process and strong early traction from hospitals and consumer buyers, she needed to raise expansion capital. Her company had a passionate following of customers, parents, supporters interested in helping their business grow. Yet, because of current regulations, Kim could not even make a passing mention of the opportunity to invest in Epicential to her 20,000 fans on Facebook. Or consider Zach Normandin, a father of 3 who lives in Brooklyn, New York. 3 years ago, dissatisfied with unhealthy snack food options available for his children, Zach created a new company to create organic, healthy snack options for all children. Today, Little Duck Organics is a rapidly growing small business, with sales expected to increase 7-fold this year. Little Duck has hundreds of thousands of consumers across the country, many of whom are passionate about the company, but Zach is not permitted to inform them about a capital raise. These consumers, many of whom are investors, would surely want at least the opportunity to learn more about Zach's company and his vision for a suite of products delivering healthy organic food to children of all ages. Yet, under current regulations, Zach's fundraising process was limited to closed-door conversations with existing angel investors, many of whom were not yet familiar with the brand. Mr. Chairman, our current system is one that rewards entrenched investors, an insular network of institutions and individuals that favor private investor access more than the creation and growth of new businesses. But with modern technology and this act, this is going to change. Lifting the ban on general solicitation will spur entrepreneurship and unlock small business growth opportunities in every corner of America, including the cities and towns that many of today's entrenched investors might consider unlikely or uncommon. But like Little Duck Organics and Epicential, we know they're not uncommon at all. Today, thousands of small businesses just like them are waiting to connect with investors who want to participate directly in our national recovery by backing a young company and receiving a stake in the business in return. We just need to open the doors and make it happen. Of course, investor protection is also essential. I believe the best protection is transparency and accountability. As an industry participant, I strongly support the SEC and FINRA oversight and regulations that protect investors while providing a more efficient flow of capital. If fraudulent investment schemes are permitted to prey upon unsophisticated investors, we will all lose. The SEC has put forth a workable set of rules to increase the capital available for small businesses by lifting the ban on general solicitation. When adopted, the rules will increase the amount of information available to prospective investors. The time is now to implement these rules, fulfilling the mandate enacted with broad bipartisan support in Congress and the President's approval without further delay. Mr. Chairman, ranking members, members of the committee, I thank you again for the honor of this opportunity, and I would be pleased to respond to any questions.
Thank you, Mr. Eakin. And now, with that, we'll recognize Ms. Veracruz. Thanks. If you just pull the microphone to you and just aim it towards you, it'll be just fine.
All right.
Thank you.
Thank you, Mr. Chairman and other members, distinguished members. I'm the founder and CEO of 18 Rabbits. I started my business in San Francisco, and we create, like Mr. Chairman said, organic granola and granola bars. So I started this in my kitchen with literally a toaster oven, and now today we make millions of bars a year that we sell. So I'm in favor of lifting this ban because we make a very easily understood and approachable product. So here it is. So our customers include people like the Fresh Market, Pete's Coffee and Tea, Duane Reade, Google, Virgin America. That's where we currently sell. And we also sell them in hotels, spas, yoga studios. All of our production takes place in the United States, in California right now, and 85% of our ingredients come from U.S. farms, most of them small farmers that I have direct relationships with. Our competitors are large companies like Quaker Oats and Kashi and Nature Valley. And in order to compete against these mega companies, we need the capital in order to raise brand awareness about who we are and what we're about and who we're selling to and why choose us. So to grow our company, what we did is we raised money from our friends and family. I sat in my father's living room and asked him for $10,000. So that's how we started the company. And then we recently closed a $500,000 round from Circle Up. Thank you, Rory. So in between all that, over the course of the 3 years, though, I applied and spoke in front of about 5 to 6 angel networks. And then I also met with 10 private equity and venture capital firms in our space. Time and time again, I was told, okay, come back when you're X amount of revenue. And then only to be told when I came back when we did reach that milestone, oh, we need double that now. So that was really frustrating, and it also takes a lot of time. And it takes time for me being innovative and getting my ideas out there to market. And also, that's not providing value to the customer who's actually purchasing our product. What's providing value is for me to get in there and continue to create and change the world with what I'm making. So the other thing that we did is we went up to banks, and we asked them for funding. And so then we were told, well, do you have positive cash flow? Do you have profit? Well, no. If I want to grow my business, I need cash in order. I need to plug all the cash I'm making from the revenue back into the business. So then what happened is, luckily, in 2009, there was the American Recovery and Reinvestment Act, where we got a microloan from the city of San Francisco for $25,000. So that really helped us. We were actually able to hire a couple of more people on our team. Right now, we're at about 8 people. And then the next thing that we got was a line of credit from a bank. So last year, we actually did have a profitable last quarter. And this year, we're growing even more rapidly, and we're seeing some profit. And next year, we'll be profitable every quarter. But what we need in order to continue to expand is access to more capital and being able to go to our loyal customers and ask them for money. So a specific example about where the lack of capital held us back was the launch of our Bunny Bars. So this is a package that you'll see, hopefully, well, you'll see very soon in Costco in October. So these little bars are geared towards kids, and they're healthy and organic, and there's nothing like them on the marketplace because of the kinds of ingredients that we use. So because we didn't have the access to the necessary capital, we had to delay the launch of the product. And then we haven't been able to penetrate the market deep or wide enough, where all of our competitors have a lot of money to do advertising and get it all out there. We don't have that right now. So it keeps us from our mission of putting healthier food in kids' bodies. So we also could be providing more bars through our community service, through our 1% for Kids program, whereby we actually give 1 bar out of every 100 bars made to kids in urban schools. So we can start telling them that, or sharing with them that we have healthy snacks, that you don't have to reach for a bag of chips. So starting a small business in America should not feel like starting a fundraising business. With lifting the ban on general solicitation, entrepreneurs like me and some of you can focus on running and building the business instead of using that valuable time to raise money. Thank you.
Thank you. And I know when you held up the bars, I think there are questions here on the dais whether or not you have enough for everyone.
Hopefully.
And I thank my friend Scott for suggesting that. So, with that, Mr. Van Winkle.
Thank you. My name is Jeff Van Winkle. I appreciate the opportunity to be here to present the views of the National Small Business Association. I'm the volunteer treasurer of the NSBA and a former chairman of the Small Business Association of Michigan. I'm also a member of the law firm of Clark Hill. The focus of my practice is assisting small and medium-sized businesses, particularly in the connection with raising capital. The NSBA was founded in 1937 to advocate for the interests of small businesses. It's the oldest small business organization in the U.S., representing more than 65,000 small businesses throughout the country in virtually all industries and of all varying sizes. The Jobs Act has the potential to dramatically and positively transform the ability of small firms to access the capital they need to grow, to innovate, and to create jobs. Counsel for Issuers have long sought increased flexibility to connect issuers with investors. The high-cost, large broker-dealer model has become a substantial barrier to getting capital to small and medium-sized businesses that are seeking to grow. The passage of the Jobs Act demonstrates a broad bipartisan understanding that existing securities laws pose an unreasonable burden on the ability of small firms to access the capital markets. The Jobs Act does this while continuing strong investor protections by retaining all existing State and Federal anti-fraud laws. The SEC and FINRA are under significant pressure from State regulators and others who oppose the Jobs Act to use the regulatory process to accomplish what they could not accomplish in Congress. We are deeply concerned that either the SEC or FINRA, or both, will impose such a high regulatory burden on issuers and crowdfunding portals that important aspects of the Jobs Act may become a dead letter. This would frustrate the intent of Congress and the President and have a severely adverse impact on the ability of small firms to raise capital. Both the SEC and FINRA must guard against complex regulations that will undermine the purpose of the Act. And instead, the regulatory framework should be straightforward and streamlined, imposing minimum necessary costs and regulatory risk on small firms seeking to raise capital. The Act required the SEC to issue a rule by early July to implement general solicitation provisions contained in Title II of the Act. On August 29, the Commission issued a proposed rule which mostly restated the applicable statutory language in the Jobs Act. No matter how the SEC ultimately proceeds, the reasonable belief standard regarding accredited investor status should be retained, and the rule needs to be written so that Rule 506 offerings not involving general solicitation are not in a worse position than they were prior to the passage of the Jobs Act. In our judgment, the traditional and almost universal practice of using investor suitability questionnaires combined with investor self-certification to establish accredited investor status should continue to be allowed and be deemed to constitute taking reasonable steps to verify that purchasers of securities are accredited investors, as is required by the Jobs Act. On balance, after careful consideration of the likely outcome of the current situation, NSBA has decided to support the proposed rule in its current form. It is better to let practitioners, experience, and courts work out the contours of the verification requirement over time. Perhaps the issue can be revisited after some period of experience with the proposed rule. Now, Title III of the Act creates a crowdfunding exception to registration requirements. This provision has the potential to be of major importance to small firms seeking capital. However, the success or failure of crowdfunding will depend upon the regulatory scheme applied to the portals and crowdfunding issuers. We are deeply concerned that the SEC and FINRA will so heavily regulate crowdfunding that only broker-dealers will become portals, and crowdfunding will become also a dead letter like Regulation A is today. We are concerned that the SEC and FINRA will miss the year-end deadline for adopting rules. Portal regulation must be substantially different from broker-dealer. Otherwise, the process will be too expensive for $1 million offering or less. The Commission also needs to resist the temptation to make issuer disclosure and reporting requirements for crowdfunding issuers a close cousin of the requirements imposed on public companies. If they do, crowdfunding will not be viable. We would like to see Congress also address a number of small business capital access issues that the Jobs Act did not address. It should address the issue of finders to match capital with issuers. We would like Congress to look at permanently and substantially reducing the regulatory burden. We appreciate the opportunity to make these remarks. Thank you.
Thank you, Mr. Van Winkle. Mr. Thompson.
Chairman McHenry, Chairman Garrett, Ranking Member Quigley, Ranking Member Waters, members of the subcommittee, thanks for the opportunity to talk about jobs, its effect on the economy, the obstacles faced to entrepreneurs in raising capital. Jobs produce far-reaching legislative reforms in this area. It added 2 new exemptions, which is frankly unheard of over the 80-year history of the Securities Act. Plus, it substantially expanded a 3rd exemption. So there's a whole new area that we haven't had before, big space. It also increased the deregulatory space for the 1934 Act, and the on-ramp creates lessened burdens for emerging growth companies. In implementing and passing this legislation, Congress followed an established template for securities regulations, which basically, as I told my students this morning before this hearing, involves 4 things. Disclosure is 4 essential pillars: disclosure, SEC review, increased regulation when there's intense selling efforts versus others, and liability to cultivate due diligence. Jobs Act followed this template. The crowdfunding bill includes disclosure, it includes focus on intermediaries, and it includes a 12A2-like liability. A+ follows this template with a focus on 12A2 liability, intermediaries, and disclosure. Implementation should follow the same template. To talk about a couple of specifics, crowdfunding and the bill introduced by Chairman McHenry and passed by one of these committees reflects an innovative path of raising securities. The challenge in this area, though, is that if you're trying to raise $1 million or less, any regulatory cost will quickly eat into what you're going to raise. And any issuer is going to look at the relative cost and benefits of different exemptions. I mentioned the several that are being applied. We heard from 2 members of our panel already who use 506, and probably they would keep using 506 to reach accredited investors after after the crowdfunding regulation occurs. That remains a dilemma for implementing that section of the Act. I think a focus on portals may be the way to go to try to get some innovative approach there. Similarly, A+ has a problem in terms of relative use. Regulation A, which is the basis for A+ at a smaller amount, has fallen into almost never being used. Now, once we increase it by tenfold, from 5 to 50, it may be used more, but it's going to be the same comparative dilemma. 506 is going to be more attractive to many people who might use A+. So that takes us to 506, which I think will be the most far-reaching effect of the Jobs Act. 506, empirical data from the SEC for the period of 2010 and early 2011 shows that more money was raised in private offerings, particularly in 506, than in IPOs. It is already the biggest form of public raising. And once general solicitation ban is removed, which will be not too far in the future, it will grow even more. I think that will be the focus in the near term for accessing capital. Now, the problem I have with 506 is that the focus is on accredited investors, which was an innovative addition back in 1982 when the SEC promulgated it. A lot has changed since then, in the sense that accredited investor is carrying a lot more weight than it did in 1982. Why? Because in 1982, the amount hasn't changed. $200,000 in income, $1 million in net worth, same as it was 3 decades ago. You all know what inflation has occurred in those 3 decades. I actually looked up congressional salaries, but I won't talk about that. The number that got my attention is that the number of investors who qualify as accredited, in 1982, it was 0.17 or 0.18 of all individual taxpayers. Today, that number, the cohort that qualifies to be an accredited investor is 20 times bigger. The focus should be on that more than anything else. And I will refer you to my testimony for my other points. Thank you very much, Mr. Chairman.
Thank you, Mr. Thompson. Mr. Ravikant.
Thank you, Chairman McHenry and Garrett, ranking members Quigley and Waters, and the rest of the committee members. I appreciate your having me here to speak. I am the founder and CEO of AngelList. We are the world's largest service for connecting technology startups and sophisticated investors. In less than 2.5 years, we have helped 1,500 companies meet VCs and angels for successful funding rounds, and our alumni have gone on to raise over $1.1 billion on and off AngelList. If you look at the map up there, there's 80,000 companies on AngelList today, spread out over the entire United States. And we've connected companies in Colorado, here in D.C., Texas, Seattle, everywhere, to investors in Silicon Valley and New York. There's some discussion here about the timing of the general solicitation and crowdfunding provisions, but I want you to know that the Jobs Act has already had a huge impact on us and our ecosystem. If you go to the next slide, you'll see that we two more, please. You'll see that we recently launched AngelList Docs, which is regulatory compliance and financing closings online. This process puts $20,000 into the pocket of every startup, and it reduces the burden of closing from a month to 3 days. And major law firms have signed up to do these closings for free. I mean, when's the last time your lawyer did anything for free? Thanks to the Jobs Act, we've had 250 companies sign up for this in 2 weeks, and that represents a net savings of $5 million if they all use this product. That's just in 2 weeks. So obviously, there's a discussion about general solicitation and crowdfunding coming up. Given our learnings helping thousands of companies, we have just a little bit of advice on what people should keep in mind as we think about implementation. On general solicitation, we think it's important that the verification of accredited investors be doable by third parties, whether it's people like ourselves or broker-dealers or lawyers, so that an investor only has to go through the process once, and then the third-party clearinghouse can help with the verification in the future and keep the cost low for issuers. Crowdfunding is obviously a very complicated issue. On the one hand, there has to be sufficient investor protection to prevent fraud. Like I said, we've helped 1,500 companies raise money. To date, we've had no reports of fraud. On the other hand, if you make the burdens too high or the regulatory compliance too high, then the good companies will opt out of crowdfunding, and they will raise money under 506 or other exemptions. And at that point, you end up with a huge adverse selection problem. At least in our part of the world, a very small number of companies account for all the returns for investors. So if those companies were to not use crowdfunding, crowdfunding would be dead on arrival. So we think it's important that the SEC and the regulators help make crowdfunding more viable. Ways to do that are to allow the crowdfunding platforms to explicitly curate what deals they show. Kickstarter, for example, which is a celebrated poster child for crowdfunding, curates heavily. The SEC should provide clarity on liability issues and what qualifies as errors and omissions that may generate liability for the issuers. Otherwise, again, the good companies will avoid crowdfunding. And finally, it's very important to keep this exemption, the crowdfunding exemption, compatible with raising from accredited investors. One of the best ways to protect the crowd in a crowdfunding situation is to also have sophisticated individual investors or VCs investing alongside on the same terms. So someone has done the due diligence for the deal. Finally, I want to thank you for the Jobs Act. It's a very rare kind of accomplishment because the constituents that you're really helping with the Jobs Act are companies that don't yet exist, which is pretty rare. Normally, there's a strong constituency already asking for whatever you work on, but in this case, most of your constituents are yet to be created. And I hope that they will also create jobs that don't yet exist and pay taxes that don't yet exist. We take the long view on this because we think that today's startups are tomorrow's Fortune 500 companies, and I think you've enabled a lot more of those, but given due time. Thank you very much.
Thank you so much for your testimony. It's very exciting to hear what the panel is doing. And I would say before I begin my questions is that we're focused on both capital formation and ensuring investor protection. Investor protection is not forgotten in either the Jobs Act nor SEC regulation, nor crowdfunding portals as they currently exist, or angel investing networks. Capital formation is inhibited when you have fraud, and it is bad for market participants, bad for startups, and obviously bad for those that are victims of this. So robust investor protection is highly important, and I obviously care deeply about that. So with that, I recognize myself for 5 minutes for the purposes of questions. Mr. Ravikant, Mr. Eakin, if I could ask you, do you believe that non-accredited investors are harmed by seeing advertisements that are directed towards accredited investors?
That's a fair question. I don't think there's any harm in actually seeing it as long as it will make those investments.
Right.
Agree.
Okay. Well, we'll start there with some commonality here. Ms. Veracruz, you outlined that you spent a significant amount of your time trying to raise capital. Do these regulatory restrictions on your ability to raise capital, does that inhibit your ability to grow your business and create jobs?
Yes, I feel that it does, because not only you have to find those people that are willing, it's a lot harder to find the people that are willing to invest in your company, and so that's why it takes so much time. Whereas if I could just go to my loyal customer base that already believe in what I'm doing, because we were actually told, even on Facebook, a customer said, I love your bars, how can I invest in your company? Well, I said, well, right now you can go out and buy a bar, and that's how you're investing in our company, because the current law forbid me from engaging him.
And to that point, lifting the ban on general solicitation, the SEC just a few weeks ago, instead of making a final rule or interim final rule, they basically put forward a proposal on lifting the ban on general solicitation. Mr. Egan, what effect does that have on linking up capital and creating jobs?
Lifting the ban will have a tremendous positive effect on helping more businesses reach out to more investors. We believe that the platforms like CircleUp provide an efficient way to start the conversation. Investors maintain the ability to conduct their diligence, to thoughtfully review investment opportunities, but it allows a spark to start the conversation. So
not putting forward a rule that can be used now inhibits job growth and the flow of capital. Is that what you're saying?
We're looking forward to the implementation of Title II of the Jobs Act.
Okay. All right. So, Mr. Thompson, you outlined a couple of things dealing with crowdfunding that are of particular interest to me. I have an idea, something I put forward to the Commission. They have enormous latitude for how they implement and write the rules dealing with crowdfunding. What I've put forward is this idea that we can start just by having as much freedom as possible to raise capital, up to $100,000, as sort of the first step for raising it up to $1 million. Would you think that that's workable, that the Commission open up first to lower space, see how that forms, and learn some best principles, best practices out of that, then keep raising it?
I think scaled enforcement has been a core part of securities regulation for decades, and that means lower burdens for lower amounts and where benefits can be achieved. And so I think focusing at a smaller amount, $100,000, could be a good try, and say what works there. And if we can figure out something that works there with some prerequisites, it might well work.
Okay. And Mr. Van Winkle and Mr. Ravicant, you both outlined that your concern about crowdfunding is how it's implemented and whether or not you can actually have a robust marketplace in full participation. And lacking that, it will be I would say to Mr. Van Winkle's comment, it was dead on the vine, I think is how you termed it.
A dead letter.
Dead letter.
Yeah.
Thank you.
If issuers need to go through too much of a process, a disclosure process, as Mr. Thompson indicated, they are going to look at other exemptions for the amount that's available through a crowdfunding portal. If you use too much of your money in trying that you might raise in compliance, it's not a good exemption.
Mr. Ravicant?
Yeah, I would add that we don't want to create a situation where only the desperate companies use crowdfunding. It should be used by top-tier companies, and that means that the regulations have to be streamlined and comprehensible.
To that, Mr. Ravicant, you outlined what AngelList is currently doing. How is AngelList using the Jobs Act right now to link up capital and help small businesses?
Yeah, right now we only connect accredited investors, and obviously you don't engage in general solicitation, so it is somewhat limited in its nature, and it will be opened up more after the full implementation of the Jobs Act.
Okay, so a lot more to come after full implementation.
We always like to lead with product. We'll build product as soon as the law allows it.
All right, excellent. Thank you so much for your testimony. Thank you for being here, and thank you for what you're doing to help create jobs. And with that, Mr. Quigley is recognized for 5 minutes.
Thank you, Mr. Chairman. I supported both these measures very strongly, and I know the administration did, and I don't see any reason why I or the administration want one to win the race. I'm not pulling for one of these acts over the other to cross the finish line, but they're both complicated. Mr. Thompson, you talked about what seems to me the real challenge and the real, intense dichotomy of trying to address this issue of crowdfunding is the smaller amounts, any kind of regulation eats up what you're actually trying to collect. But on the other hand, when you're dealing with smaller amounts in the manner in which we're talking about less sophisticated investors. If you could give a few specific ways to try to address that if you were advising the SEC.
I think one way is to try to bring in a third party to carry some of the load. And if portals, as Mr. Ravikant suggested in one of his slides, can carry some of the load of verification or regularization, then the costs go down. And so I think the SEC might well want to look at focusing on a subset of portals who have the capacity and the affinity to want to support capital raising and are willing to commit some of their resources toward developing the platform that will reduce the amount of fraud, and as opposed to making it all on the sellers who have sometimes overly aggressive incentive to sell and get the balance wrong. So I think the portal focus has potential in dealing with this small amount.
Mr. Ravikant, you talked in your testimony, I believe it was, I think it's along the same lines, the sophisticated investors next alongside the unsophisticated. Is that the manner in which you described what Mr. Thompson was saying?
Yeah, I would say it's a couple of things. As Mr. Thompson said, the portals can help in the prevention of fraud, but the SEC has to enable that. The examples I would give are, number one, we can help curate the deals. We have lots and lots and lots of data on these deals, as well as competitive companies and so forth. So by curation, we can help the investors get some data. We can build in tools for transparency. We don't want the reputation of being a hotbed for fraud, obviously, or the investors won't come. And since we deal with a lot of sophisticated investors, we would put in a lot of protections. One other protection, which I talked about, which you just referred to, is having the sophisticated investors invest alongside the crowd on the same terms. But that may be uniquely possible for us, for tech startups. It may not be possible for other local businesses or consumer goods startups where you don't have a large native base of sophisticated investors.
And Mr. Van Winkle, you understand, and I know you agree, that this is an extraordinary opportunity for investment for small businesses, but we want to get it right as to the point that you don't want this to be viewed in a few years as a reservoir for people who are out to milk unsophisticated investors.
I would agree with that. The issue.
What's your thought on how to balance this?
I mean, I think the elimination of the public advertising and solicitation ban has been talked about by practitioners for a long time, that as the markets have matured, that there's investors are selective, whether they're a small investor or a larger. When you think, we heard described by the panel, they had to go out and seek many people who turned them down at times because they'd have to keep going. I expect that will continue on, that we're not going to see a sea change of the investing public because the law has changed. What this will do is it will just create many more opportunities to connect folks. And the existing anti-fraud protections will continue to protect those investors. So I think it will enhance the opportunity to raise capital in its current structure without injuring investors.
Ms. Veracruz, your personal experience in that vein, you would also agree that these are sometimes very small investors for the first time, and the reputation of this type of investments is just as important as your ability to get them. It's key to it.
No, I agree. So was there a question, though, there?
No, I just wanted to see, in your personal experience, particularly with smaller investors, their concerns about something along the lines. I mean, they're typically used to investing in Quaker, as you said. You're a little different. So the reputation of a pool like this is as important as anything you can do.
What's really, well, so I think this speaks to what you're talking about. But what I like to do is be really transparent about where we are as a company. And it's actually a lot easier for them to embrace a company of our size. The financials are very simple. You know, it's just, and our expenses are very easy. We have marketing costs and payroll and a little bit of research and development, but it's very easily understood by a non-savvy investor by just having a couple of conversations with them. And then by seeing the financials, they can see where their money is going, and then also by seeing us out in the community actually selling products, they can see that we're actually selling a viable product.
Great. Thank you.
The gentleman yields back, and I'll recognize myself for 5 minutes. And again, I thank the panel. And I also thank the panel specifically for their entrepreneurial spirit, which is what makes America great. So this morning, before I came here, Professor was teaching classes. I was on C-SPAN doing a TV interview, and a number of the questions that were coming to us was, why isn't there more bipartisanship in Congress, and why doesn't both sides of the aisle just put controversies aside and work together? And I could actually point to this piece of legislation, and I actually could point, I mentioned actually Ms. Waters' name on there, and they said, actually, there is legislation that we have worked together on, and we have worked together and been able to pass it through our subcommittee, full committee, and right on through the process. And I said, so don't always believe everything you read in the newspaper as far as all the antagonism. The Jobs Act is an example of true bipartisanship. But that's what happened here in Congress. And then it gets out to like what we always like to call the bureaucrats. In this case, the bureaucrats fall in the category of the regulators or the SEC, who put in what I'm hearing from the panel, effectively an impediment to the will of Congress. Now, I know the gentleman from Connecticut was here earlier. I guess he's not here right now. And he talked about how in the military there's a process called a stand down, right? When they saw that something goes wrong, first they stand down and see what's wrong and then go forward from that. Would that have that occurred in the situation in the last session of Congress when we had the financial meltdown of '08, and then there was a stand down and do a thoughtful analysis of actually what the problems were that led up to that, and then pass a piece of legislation that resolved that problem? That would be an appropriate stand down and resolve and reform. But we didn't have that. We had 2,000-page Dodd-Frank that came from it, addressing all sorts of areas that were not the cause of the problem, and then not addressing areas such as this one that could actually help us get out of the morass that we are in. So with that, I throw this to the panel, and maybe Mr. Eakin or any other members might want to talk about this, as to we've already heard somewhat the effect of the SEC's standing in the way to the will of Congress and what the impediment will be to the cost of industry. If you look at the Commissioner Aguilar's statement, it appears in his position he wants to create a whole new set of regulations to impede capital formation, and as I say, that runs directly counter to the initial intent of the Jobs Act. In his dissent is entitled, actually, Increasing the Vulnerability of Investors. So I'll start with you, Mr. Eakin. I don't know whether you read that dissent or not, but the caption, Increasing the Vulnerability of Investors, is that what Congress was doing when we passed the Jobs Act with our intention? Were we increasing the vulnerability to investors who might want to invest in this granola bar company next to you?
We'll leave the interpretation of Commissioner Aguilar's words to himself, I think, on that one. We support the full implementation of the Jobs Act as written and believe increased transparency and accountability in the marketplaces and the funding portals under the oversight of a strong SRO and the SEC will improve the capital formation in the country.
Anyone else on that? Mr. Van Winkle?
I would simply say that there are people standing on the sidelines waiting to see how, for example, the crowdfunding regulations are going to look and what's going to be required. They're prepared to move forward, put their offering of their business out there, and connect that capital with the business. We think that will be very beneficial. I believe that's what Congress and the President wanted with the passage of this Act.
Can you also just, since you're speaking, can you explain in your testimony, you talk about existing security laws pose an unreasonable burden on the ability of small firms to access to capital markets, harming economic growth and job creation. Those were some of your words. That's
correct. So the framework before the Jobs Act was such that it's very difficult for the small issuer, the business that's out there that's looking for capital to connect. Those networks aren't there. They need to be able to have more opportunities to be able to connect. The ban on solicitation, the removal of that, will be very helpful in connecting those folks. These investors often will still pass on a deal. They might not understand it. Maybe it's not as simple or straightforward as they thought, so they'll walk away. But there will be transparency, as Mr. Eakin indicated, and we think that will be very helpful.
So, and I think Mr. Quigley raises a good point, and Mr. Thompson and Mr. Ravicant, can you address it a little more fully? If I'm the investor going forward with the Jobs Act as Congress wanted it to be implemented, why should I feel assured that me as an investor, maybe not a sophisticated investor, would have adequate protection under congressional intent of the Jobs Act?
The Act itself is not just a blank sheet. It contains a large number of guidelines for implementation for the reg. It says, SEC, do it, and here's what you should do. Disclosure, intermediaries, liability, all that's in there.
That's what my protection is. Mr. Ravikant?
Yeah, I would say the portals like ourselves and Mr. Eakin's portal will bend over backwards to try and prevent fraud. There's no such thing as a completely foolproof system, but our reputations and businesses are on the line.
Gotcha. And with that, I think I'm over time. So thank you very much for the panel. And the gentlelady from California, who I was referencing today.
Mr. Chairman, I'd like to thank all of our participants, our panelists here today, but I'm especially pleased about Ms. Vercruse for your appearance here today. When I talk about business, small business and entrepreneurs, I really like to talk to people who do it, who have their hands on, who have to meet that payroll, who understand what it really means to have to go out and find investors and money. Consultants and lawyers and all that are fine, but I really appreciate your being here today and the way that you have described the development of your business. I also know that oftentimes you must seek capital from various sources, and I'm very pleased to see that you're able to get that microloan of $25,000. That was part of the American Recovery and Investment Act. So that makes me feel good that what we did is real and that it certainly had a positive impact on businesses such as yours. So again, I appreciate your being here. As a matter of fact, I worry a little bit about the time that you're spending on this, because I know you must spend that time in your business, a small business like that, where you're hands-on. You don't need to be sitting up here in Congress for hours talking about whether or not they're moving fast enough. The Jobs Act is real, and it's going to happen. And I want to tell you, even with Dodd-Frank, what we have been doing, and oftentimes in a bipartisan way, looking at the soft spots, the gray areas, and we have had remarkable cooperation from both sides of the aisle on straightening out some of these things in Dodd-Frank. And I think with the Jobs Act, between SEC and all of us who care about this, we will do that. So I'm very confident. I'd like to, if I may, Mr. Chairman, I'd like unanimous consent to insert into the record a letter that was written to us by many of those consumers and organizations that are paying attention to this particular legislation. This letter was sent to the Securities and Exchange Commission related to the rulemaking on general solicitation and advertising under Jobs Act by a group of consumer and investor advocates, including Americans for Financial Reform, Public Citizen, and Consumer Federation of America, among others. First, this comment letter from group says that they would have opposed the SEC going straight to an interim final rule on general solicitation and advertising because they believed there were a number of issues that warranted a public comment period. I'd like to know, Mr. Thompson, do you think that it's reasonable that the SEC propose a rule on this issue rather than going straight to an interim final rule, given that the ban on general solicitation and advertising that the Job Act lifts has been in place for decades? Shouldn't the implementation of its repeal be open to a robust dialogue?
The SEC rulemaking is never the end of the story, and certainly in recent years, what happens after rulemaking is litigation, with a focus on cost-benefit analysis. That's been a great concern of members of this committee. So the SEC has to worry about, will its rulemaking stand up to a challenge that is likely to come? And that suggests paying attention to notice and comment, having a period for notice and comment, reflecting on what's commented, and then making the final rule. So by not doing that, I think the SEC was increasing the risk of litigation and increasing the risk of the rule not being implemented as quickly as it might otherwise.
Thank you very much. Just quickly to Mr. Ravikant, I want you to know that some of the comments about members of this panel about our small businesses not having to spend their limited capital trying to be in compliance is something that I certainly I'm concerned about and I support, and the idea of a portal or portals that could help with that, I think is extremely attractive. But having said that, as someone who works in the world of Rule 506 offerings, do you think it's fair to say that the SEC should move slowly and deliberately with the way it lifts the general solicitation ban?
Yeah, it honestly impacts us less because of the nature of the companies that we work with already have access to sophisticated investors. That said, the strange part is that a lot of companies accidentally or not knowingly violated the general solicitation ban on a regular basis. So in that sense, it does need to be modernized quickly. To give you an example, this morning, my fiancée forwarded me a video on YouTube pitching me to invest in a startup, me personally. So this company had gone and made a rap video singing about me and hoping I would invest in their company. Now, clearly, that is a violation of the general solicitation ban. I don't think they're doing any necessarily harm by it because it's addressed to me, but it shouldn't be sitting on YouTube. So things do need to be modernized.
Thank you, Mr. Chairman. I yield back the balance of time I don't have.
Thank you, though. I'm still trying to get my head around rap solicitation. Dr. Hayward.
Sounds hip to me.
Thank you, Mr. Chairman. Mr. Ravikant, I was your rap star fan base aside, and that is really neat, actually. But I was interested in your comments about the cost of regulation, and of course, the entire panel has alluded to them as well. But I think the big theme that we face in this Congress is that we're trying to, and in this committee, of course, we're trying to balance consumer protections, investor protections, with the cost of, as Ms. Cruz has described so eloquently, with the cost of trying to navigate that system. We can keep layering on requirement after requirement, sort of belt, suspenders, duct tape, you name it. But as you have pointed out, eventually it stifles growth, in fact, relatively quickly. Could you comment a bit further in particular about the liability issues that are also incurred? Because I think one of the subtexts of the regulatory burdens is not only the cost of compliance per se, but also the anticipated cost potentially of liability. Could you talk a bit more about that?
Yeah, I'm really not an expert in this area, but my understanding is that as part of the Jobs Act crowdfunding provision, that the directors and officers of the companies are directly liable for any material errors and omissions. So what we're basically asking, therefore, is some kind of a checklist from the SEC as to what disclosures a company should go through, and then know that it's not subject to potential liability in an ex post facto manner. And that will help issuers have some comfort on using crowdfunding. Part of the problem is those liability provisions do not exist on the 506 exemption side. So a company going into crowdfunding is going to have that additional burden. So the more streamlined that process can be, the more transparent a checklist or a set of guidelines would definitely help a lot.
Thank you, Mr. Ravikant. Mr. Thompson, can you speak to that issue as well?
Sure. As Mr. Ravikant said, 506 doesn't have liability because of the Gustafson versus Alloyd case from 15 years ago, but crowdfunding does. And it's 12A2-like, which I'm not sure what that means, but someone who drafted it must know what it means. But there is some liability there. And so that's why I think many investors will be using 506 instead of crowdfunding. Is there a way to give some safe harbor? I think the rulemaking for that hasn't come yet. It's not due yet. I think we'll see some attention paid to that. It's hard to do. So I can't predict it, but I don't know exactly how it's going to look.
Would any of our other panelists care? Ms. Cruz, have you? Does that play on your mind when you think about how you interact with potential investors?
The part about the liability?
Yeah, about being held liable for.
Well, I just have to speak to my own personal experience, and that is that I was just asked by one of my my business partner, actually, and he's a major investor in my company, whether I had D&O insurance. So to protect against that. So that's how we would do it. But I, as an entrepreneur, though, didn't know before about the existence of D&O insurance, so then that leaves my husband and I completely liable if we don't have it.
Right, right. Mr. Eakin, is that?
I very much agree with Mr. Ravicon's sentiments in having a healthy, attractive ecosystem of companies wanting to use this provision. And one way of doing that is providing clear guidance to those issuers of how they can protect themselves from a liability perspective.
Thank you very much. And I yield back, Mr. Chairman.
Thank you. And Ms. Maloney.
Thank you, Mr. Chairman, and thank you for holding this hearing, and I welcome all of you. First, I'd like to say that I supported the Jobs Act, and I worked with my colleague, Mr. McHenry, on the crowdfunding provision of the bill, because I believe that we should be able to have all kinds of tools, investors and companies at their disposal to grow and create jobs. I appreciate Mr. McHenry accepting one of my amendments to make SEC oversight of these sites more robust and to combat against bad actors. Now, the Jobs Act just became law in April, and we've had 90 days, and it said it should be done in 90 days, and it's no question we're past that time. But I don't think any of us feels that we don't need to get it right, especially since the SEC's job is to protect investors and guard against the bad actors. And I would like to ask Mr. Thompson, despite the well-established need for financial regulation reform, we're still recovering from this great recession, the majority has made considerable efforts to delay implementation of the Dodd-Frank financial reform bill, while supporting, in contrast, an expedited implementation of the Jobs Act. I, for one, think we should finish the rules on Dodd-Frank first, but I am concerned that the majority's attempt to rush the Jobs Act could severely weaken investors' protections and the integrity of American capital markets. And in your written testimony, Mr. Thompson, you stated, and I'd like to quote your words back to you, the largest impact of raising capital from the Jobs Act is likely to be in the expanded use of offerings under Rule 506. That is, offerings issued after the removal of the ban on general solicitation. Is that correct? And if that is correct, the implementation of Section 201 is no small matter. Would you agree?
It will be the biggest impact because it's already the largest source of capital raising, and once general solicitation is removed, it will get even bigger. And so it's appropriate that it's first on the list. But the SEC has, they've got a lot of balls in the air. They have to do them all. There were 90 sections of Dodd-Frank that required them to do something. I mentioned there were 2 new exemptions under jobs. They are doing them all. I think 506 needs to be a focus. They've still got a 506 regulation from Dodd-Frank to remove the bad boy, to add a bad boy exemption to 506. That was proposed a year ago. I think given the greater use of 506, that rule needs to keep moving. So I think all these 506 rules ought to be on the table first.
I agree. And Chairwoman Shapiro stated that she is giving serious consideration to all these rulemaking approaches. And she says, and I'll quote from her letter, due to the high level of investor interest and strong desire for a comment period expressed by a number of commentators in the public, however, upon further reflection and analysis, I now believe that the more appropriate approach in this matter is to proceed per our normal notice and comment process. This was in response to McHenry's letter that she should bypass the normal notice and comment process. And I think something that's so serious to protect investors, and the fact that the public has notified the SEC that they want to comment on it, I just want to know, do you agree that the approach the Commission has decided to use for 201 to allow for the comment period. I think that's important. Do you agree, Mr. Thompson?
I agree, and I think it also assists in looking ahead toward litigation because the shorter the interim final has the potential to increase the challenge to the rules that are implemented.
And McHenry goes on in his letter to request internal documents and communications related to, quote, potential commission action to implement Section 201 of the Jobs Act. And this committee has a legitimate role to conduct oversight. But in this case, the agency is simply following normal rulemaking process. And I would argue that their demands and documentations is just adding to the time when she is following the normal rulemaking process, which allows a comment period. And I would say that their actions are somewhat disingenuous, particularly when they have voted to underfund the SEC. They wanted a cost-benefit analysis, tried to pass that. Believe me, if you pass the cost-benefit analysis, we never would have gotten to any rules. And their real action to sort of stonewall and stop the implementation of Dodd-Frank. And I would like to respond to Mr. Van Winkle that you were saying the money is on the sidelines because we haven't come forward with the rules. But if you look at all the analysts that are coming out from the economists, whether it's Zandy or it was McCain's economists or Krugman from the Times or any of them, they're all saying that money is on the sidelines waiting for the election, that is the real reason. I've read about 5 different reports on that, not the fact that the rule isn't in place. And I would say that the Jobs Act went into effect, and I think it's very important that the SEC get it right when it comes to protecting investors. My time has expired, and I yield back, and I thank the Chairman.
You caught me not paying close enough attention to the clock. Ms. Zico.
Thank you, Mr. Chairman. One of the biggest concerns I have with the SEC's proposed rule is the verification of accredited investors. It seems the proposed rule would disincentivize the issuance of new securities for fear of legal retribution. Mr. Van Winkle, you allude in your testimony to issuers currently being able to rely on written statements from investors that they are accredited. Could you explain why the new standard set by the SEC in its proposed rule is a problem and how it could minimize the positive effect of the Jobs Act?
The proposed rule doesn't, I don't think it minimizes that. Under its current structure, what I described is 40 years of tradition of inquiring of an investor, are you accredited, do you meet these standards, and telling the issuer typically has some basis of knowing that or has had some connection with that person. The proposed rule gives room for the issuer to continue to sort out what makes sense, and will be able to verify that. So if the proposed rule is implemented as it is currently written, I think it will create the right playing field for the Jobs Act implementation to move forward.
Do you think that the proposed rules are a little too subjective?
I don't think, based upon what I know now, that they are too subjective. We may know more 2 years from now, but there's plenty of protection in place to keep issuers honest. Quite honestly, what we heard today is that issuers want to tell about what's going on in their companies. That's been my experience in my practice, that issuers want to disclose that information. That's what's going to keep the honesty going in the system.
As I understand it, if the SEC rule were to become final, there would be a double standard for investor accreditation. Issuers using new solicitation exemption would be held to a different standard than other issuers. Now, Mr. Van Winkle, do you believe that could create a problem?
I'm certain someone could find a problem there. I think we are concerned that we want to make sure that the existing exemption, if you're clearly not using general solicitation, that you can continue to follow that pattern. And whereas the issuers who are seeking to find a broader expanse of investors may have a slightly different standard to apply, and they'll sort through that.
So if an investor were to put in writing and under contract that they meet certain net worth or income requirements to purchase a private issue security, do you think that is sufficient information for an issuer to rely on?
Yes.
Even under the current proposed rules?
Under circumstances, that may be very correct. As you alluded to, the subjective nature of it, the flexibility means that the issuer will look at, is this the appropriate investigation for this level? And we do that all today in practice. We make sure that there is a relationship that's established and there has been appropriate verification.
So in your opinion, did the SEC go far beyond what Congress asked it to do with its proposed rule on solicitation?
The proposed rule seems to be in line with what I understand Congress's intent was with the Jobs Act.
Okay. So one other question, Mr. Van Winkle. The Jobs Act received a fair deal of criticism from certain groups who argued it could lead to increased fraud, or that it somehow relaxed standards and increased risk to investors. You mentioned in your testimony, but could you explain why fraud protections are not weakened by the Jobs Act, and do you believe that the SEC erred on the side of overcaution, thus damaging the intent of the Jobs Act?
The Jobs Act, Title II of it, greatly expands the opportunity and the potential investor pool. That may or may not lead to higher probability of fraud. I don't know. What I do know is that the concern is that there are more issuers that would be causing fraud by not disclosing. So the disclosure regime is still going to remain for issuers under Rule 506. They still need to disclose what they're supposed to disclose. I can't predict that whether or not we have more potential investors, whether there will be more fraud. I think the fear is that there will be people just coming out of the woodwork who are advertising fake businesses. I mean, that's what my experience has been that issuers are very concerned about making sure that they have a reliable and viable business before they bring in investors.
Thank you, Mr. Van Winkle. I see that my time has expired.
Yeah, on this time I was paying attention to the time. Thanks, Mr. Canseco. Mr. Lynch.
Thank you, Mr. Chairman. Let's stay right on that point about the fear of investor fraud. Many of the observers believe that the most significant provision of the Jobs Act is, in fact, at least from an investor fraud standpoint, the elimination of the ban on general solicitation and advertising for Section 506 offerings. Indeed, I recall a statement by Chairman Shapiro, and actually I'll quote her. She says, we must balance, this is right before the Jobs Act passed. She said, this is a quote, we must balance our responsibility to facilitate capital formation with our obligation to protect investors in our markets. And she goes on to say, I am concerned that we lack a clear understanding of the impact that this legislation and its exemptions would have on investor protection. And sort of echoing what you just said, Mr. Van Winkle, the New York Times editorial board, which I don't normally quote, this is the first, said soon retirees, this is 2 days after the SEC issued its proposed rule, it said soon retirees and other investors will be barraged with advertisements for private stock offerings such advertising, what used to be banned under Federal securities law, will make it easier for hucksters and rip-off artists to lure people into unsuitable investment and outright frauds because private offerings are not subject to the disclosure requirements and other investor protections that apply to publicly held companies. What do you think about the concerns raised there in terms, I mean, given the fact that a lot of people, even before this relaxation, had trouble really discerning the disclosures to begin with, and those were more sophisticated investors. Now we're going to have general solicitations. Do you think that presents a danger to the market and to average investors?
There's a number of pieces to that question, and I just observed these comments in response, and maybe it's helpful. The fraud, it assumes that there's going to be many more issuers that are going to be promoting businesses that are fraudulent, I guess. That's
well, there's more opportunity for fraud.
because we have more investors, potentially?
No, but because we have less protections against fraud.
The protection against fraud is really on the issuers. It's the obligation of the issuers to be honest, to disclose what they need to disclose, and what they communicate to those potential investors to be truthful. I mean, if I'm distilling that down, the fact that—
Well, no, also you have a general population that is more vulnerable. Therein lies the opportunity for fraud. You have a general population that now can be solicited openly and without, and they don't have the protections, the ability to protect themselves. That's what creates the opportunity. I'm not as concerned about companies that are out there now and operating under the previous rules. I'm worrying about opportunities that will present themselves where investors won't have that protection. That's the danger.
Right. So we have to have an issuer that's fraudulent, that's now going out into the marketplace and advertising and seeking to bring in those investors that aren't going to ask those questions. We certainly don't know what that looks like. I mean, that's one of the concerns that people have. That's why there's we're concerned about the change. I will simply say my experience has been from the very small investors, and I've worked with very small companies that have raised small investments, that almost every single investor, potential investor, looks at issues and asks questions. I've seen that from what I'd consider to be very unsophisticated financially, but smart business people, or the smart retiree who's very concerned. Now, that retiree has to actually have cash to put into the business in order to be an investor. And so that, as a practical level, is going to be an element of protection.
Well, let me attack this from a different direction then. Even though lifting the ban was required under the Act, the SEC still had an ability in the rulemaking process, I think, to provide some level of protection still for the investor. Did the SEC miss that opportunity, in your opinion?
I don't believe the SEC has missed it. If, based upon experience, 2 years from now, they observe that they missed the mark a little bit, they're going to, they may move that. But just based upon what we know now, based upon what the SEC knows now, in its best judgment, I think it issued the proposed rule which said the issuer is going to have to make those determinations. And as was previously said, there's a subjectivity to that.
Okay, fair enough. Thank you. I yield back.
Thank you, Mr. Lynch. Mr. Pierce.
Thank you, Mr. Chairman. Fascinating discussion. Appreciate the testimony of every single one of you here. It's those of you sitting out there, not those of us sitting up here, that give me hope for the future. I really appreciate the depth, Mr. Ravikant. I really appreciated your presentation, the sophistication as a small business owner. I could have used help like yours way back when. Ms. Vera Cruz, again, your struggle is starting with one or two people are things that are very familiar to me. So I appreciate that. I find the fascinating discussion because there is a definite split in opinions from this side of the table that somehow we're going to protect the general public. We don't seek to protect the general public from people who want to read your palms. You can advertise that. Walking down here in Arlington, I can find palm readers everywhere going to hook me up with a different generation that passed away several decades ago. And I don't get protected from that. I go out to Las Vegas, and I slap my money on the roulette wheel where I know the odds are far less than investing with any single one of you all, and there's no protection for that. And yet somehow we're going to protect the general public with the same people who watched MF Global from inside. We had 100 and something protectors of the general public, protectors of the investors sitting in the room watching what was going on. Sometimes the very highest level protectors. And somehow they didn't catch that we're about to defraud the investors. Some guy named the J.P. Morgan Lehman Brothers, and then that guy up there named Madoff, $50 billion maybe. And they were watching him very closely, and yet we're going to tell Ms. Veracruz that she can't advertise on Facebook. If you want to stick $100 in my company, you might not get it back, but I think you will. We're going to stop that. I just can't imagine where we're coming from in this country right now. We want to unleash the power and the innovation. People are responsible. If they stick $100 in Ms. Veracruz's 18 rabbits, maybe they only get 16 rabbits back. I don't know, but and then we hear that the economists all are in absolute declaration that investors are sitting on the sidelines waiting for the election. Now, the President himself said a couple of years ago that people are hoarding their money, and corporations are hoarding their money. They shouldn't be doing it. They're hoarding their money because they're uncertain. The money is on the sidelines because of uncertainty, not some election. Mr. Ravikant, I agreed with almost everything you said, but I do want to dig a little bit deeper on one thing. I think you said in your testimony or in your answer to a question that maybe that you don't want crowdfunding for the smaller companies, that you would want to reserve it for the larger ones. If I misunderstood, that's the reason I'm asking, because I'm thinking directly of the 18 rabbits. I can see where if she could just advertise on Facebook page, she probably would have enough to expand it. So give me some clarification what you're saying.
That was misinterpretation.
Okay.
Misspoken. Yeah, I actually think it'll work better for the smaller companies
Okay.
than the
All
larger
right.
ones. Absolutely. Less at risk, smaller amounts, smaller denominations.
Okay.
Obviously depends on the regulatory cost.
Okay, I was afraid that I'd misunderstood. Mr. Thompson, one of the things that you had talked about several times is sophisticated investors, people who are knowledgeable. Again, putting the backdrop of the gentlelady sitting straight down the table from you there with a small investment that could grow significantly with a few people pitching a little bit of money and $500 apiece. Tell me a little bit about the sophisticated investor. I heard you use the term, and I'm not diminishing the requirement, but also I'm thinking about her situation.
So accredited investors includes $1 million in assets, which includes your pension, your retirement. Whatever you save for retirement counts for that $1 million and $200,000 or $200,000 in income. So that's a large group that has disposable investment income, and it's growing.
If I could interrupt because I'm running out of time, but just apply it to her request. Why can't we make it available for her to advertise on Facebook for people who maybe don't even make $20,000 a year to stick $100 in it?
I think after the ban is lifted, she'll be able to do that.
Okay.
For the accredited investors.
And you don't think there's some great risk there?
There's a risk because I think we've dipped too deep into the pool, but it will expand who she can advertise to. But that's different than what's on the other exemptions.
Okay, and I see my time has elapsed. If we go to a second round, I've got a couple more points. Thank you, Mr. Chairman.
Thank you, Mr. Pierce. Mr. Hurt. Thank you, Mr. Chairman. I want to thank each of you all for appearing today. And I come from Virginia, and we have a rural South Side district where we have unemployment that's much higher than the national average. In many places, we have some places in Virginia's 5th District that have unemployment as high as 16%. So the jobs issue is very, very important, very, very real to us in terms of sustaining families, sustaining businesses, sustaining farms. And so this is all very good to hear that this Jobs Act that was adopted with bipartisan leadership is, our friend Mr. Fincher here, has been adopted with bipartisan leadership and seems to be making some headway. And a lot of the conversation today has been focused on the SEC and a lot of the financial regulation, which I think we all would agree, despite the fact that it is polarizing, it seems, and one side accuses the other or each other of various offenses. I think we all agree, certainly on our side, that there are regulations that are very, very important to making sure that we have an efficient market and a market that protects consumers. And I don't think there's anyone on our side who doesn't believe that. But I think that what we see is that regulations have costs, they have impacts, and that we need to be sensitive to that because the consequences are very real. It means no jobs or fewer jobs at a time when, again, I have places in my district with 16% unemployment, and I have to answer to those people, and I should answer to those people. And so I guess my question is a much more general in nature and ask you to back out of the SEC, the granular look at that level. But my question is really for Mr. Eakin. Is it Very Cruz? Very Cruz. And then Mr. Ravikant. If I could just have you all talk, just generally speaking, about the regulatory burdens or regulatory issues that you see that are apart necessarily from the financial regulation and from the Jobs Act. Can you talk about the atmosphere for job creation in terms of regulations, whether it's an oppressive tax code, whether it's environmental regulations, perhaps all well-intentioned, but environmental regulations that affect business, and then finally, labor issues. I mean, these are all things that we have control of here in Washington, and I should say we don't have control of. We have responsibility to those very important issues. How do they affect job creation, in your opinion? And if we could just go down the line and 30 seconds, 45 seconds apiece. How's that?
Congressman, I appreciate the opportunity. I think it's a little bit beyond my expertise, focusing on marrying accredited investors to startups through Circle Up has been our primary focus on the Jobs Act. So I think it's I'll pass to another.
The regulations as far as the jobs, providing more jobs? Is that?
Yeah, I would just love to hear your input in terms of access to capital, in terms of a regulatory climate that encourages job growth as to one that suppresses it. And if you have general comment.
Well, I think the general comment would be I do like how there are some micro-lending organizations out there right now that they very much are into job creation. I sit on the board of Working Solutions, and we provide microloans to small businesses in San Francisco and the Bay Area. And it's that they all have to come to the table with a proposal about how many jobs that they're going to create and what sectors that they're going to affect and how their jobs are going to help their businesses grow and thrive. So I think that's something that's definitely working. The regulations don't really, at my stage of business, they don't really burden me at all. Right. This was a new thing going from an LLC to a corporation. I had some things to learn, but luckily Circle Up helps with that.
Right. Do you have anything to add, Mr. Roberts?
Yeah, so it's a great question because I think that all of us here probably have a smartphone in our pocket right now. And so because of that, what's happening is a lot of technology companies that before would have stayed just in the technology space are entering other adjacent spaces, and they're running into regulations. Example with the Uber cab with its various disputes with the taxi companies and taxi commissions, Airbnb with the hotels, and so on. So this democratization of local services is going to run into a lot of regulatory issues and will be an interesting area to keep an eye on. To give you an idea of some of the craziness going on, San Francisco Bay Area now has 2 services that have peer-to-peer taxis where Rory can roll up in his car and pick me up, and I have to leave him a donation based on the distance travel. So these kinds of things are very innovative on the regulatory side.
Thank you. That's very helpful. And I yield back the balance of the time.
Thank you, Mr. Hurt. Mr. Fincher.
Thank you, Mr. Chairman. I'm going to pick up just for a second on my colleague where Mr. Pierce left off. About how so many times I'm a freshman, a member. I haven't been up here as long as some of my colleagues, so not an expert politician. I'm just a business person, a farmer from Tennessee. But are we really here to protect? Usually Congress, in my opinion, when I go home and talk to people in my district, when it comes to jobs, when it comes to work, how the government's in the way, that we're not helping, we're making things worse. And bad characters do need to be punished when they step out of line. But so many times the more rules, the more regs that we impose on business owners only hurt the ability to grow the economy, to lower unemployment, and to get the private sector back in the driver's seat. And a few minutes ago, when one of my colleagues on the other side of the aisle was trying to talk about the Jobs Act versus Dodd-Frank, I mean, really it's a big difference there in Dodd-Frank and the Jobs Act. We somehow must get back to the place of there's personal responsibility. And people are out there making decisions. They can think for themselves. We're not here to make sure that the world can go on and everything needs to travel through the House of Representatives or the Senate or the White House, that people can make decisions for themselves. Your testimony today has been great. Mr. Ravikant, on the end, you comment for me just for a second. The Jobs Act, I was looking at a couple of questions about how many dollars of capital, how many jobs it would create. If this had not been put in place, do you think the SEC would have been able to clarify or make decisions making it easier for companies to go public without the Jobs Act?
I actually don't know anything about the public side of it, unfortunately. I deal much earlier stage, but I will say that thanks to the Jobs Act, there will be more capital for small businesses. Some of it, in fact, a lot of it will come from the 506 exemption. Some of it will come from crowdfunding. And so eventually there will be more public companies. We just have to give it time. It's a 30-year cycle. So we have to look a little forward.
Absolutely.
But to give you an idea, just Chairman McHenry's amendment to the Jobs Act, which allowed us to offer that online documentation, we can save companies $5 million in the first 2 weeks. That's $5 million that's better used to hiring people and building product.
Absolutely. Any more comments from the other witness, Mr. Deacon?
Sorry. We believe that the Jobs Act is a great stimulus to helping small businesses raise more capital more efficiently. And through portals like Mr. Ravikant's and as well as Circle Up, we're excited for full implementation.
Well, and let me finish up by saying this. I was thinking last night I couldn't sleep. I sleep about 3 hours a night now, and I'm in this job. This is not about any past political arguments or things that one party or another party has been doing to each other. I don't know what happened in the past. This is about going forward, and we've got to get this right if America is going to be able to get back on top. And if we don't get the private sector growing again by allowing us to get out of the way, then it's going to be hard to do. So that's what we're trying to do up here, and hopefully both sides can work together and make that happen. So thank you for your testimony. Appreciate you today. Yield back.
Thank you, Mr. Fincher. Chair is going to yield himself. Let's see, Jack can yield myself all the time I want, right? Oh, I like this. No. And we're not going to do a second round of questions, but we'll consider this sort of a lightning round. Two things I want to touch on. One, we were hearing in some of the questions the comment general population. I want to make an additional clarification. It's not general population. These are accredited investors. That was a part of that discussion. And there's also sort of a philosophical split here, and I may be an outlier in this. I have an intense concern that often in our attempt to protect everyone, we take part of our population that hasn't made that threshold of being accredited and take away their opportunity to find the golden egg, to invest in something that really, over their lifetime, gives them that opportunity. And my great fear is, we often end up in these debates of the haves and have-nots, but if we've made the barrier so, okay, you're accredited, you get to play, you're a small investor, we're going to add barrier and barrier and barrier where no one wants you to really even knock on our door, that we never give them the opportunity to start that process of taking risk and ultimately accumulating wealth. And forgive me if I mispronounced the name. Is it Ravikant? You're doing some things that I find fascinating. In building a portal that allows a small business to start to be able to use your standardized documentation, Walk me through that as sort of quickly as you can of how that benefits a small upstart.
So today, if you're a small business and you find investors, whether through AngelList or Circle Up or wherever, you have to then negotiate a term sheet and negotiate the investment. Before the Jobs Act, if you wanted to if you wanted help on that regard, you'd have to go hire a lawyer or work through a broker-dealer, both of which were very expensive. The Jobs Act allows us to offer optional closing documents, soup to nuts, online. We created a beautiful visual process, well-designed, Internet-based, lays out all the standard terms. Your lawyer can even work with it, and it works very quickly. And it takes the process. It used to take a month of back-and-forth negotiation and generating huge documents and red lines and all that. And it's instant. It's basically instant. And we made it free not just for the companies that raise money through AngelList, but for any company.
And that's for the business side. How about if I'm the person that absolutely loves Ms. Veracruz's product, and I've sent her a note over Facebook, and she says, I can't talk to you over Facebook because I go to jail, but you could go take a look at this website.
Correct. You can talk to
And then could I actually ultimately, when it's established, could I invest in her through you?
Well, we can make the introduction after we establish the investors' accreditation and their sophistication. We actually go one level beyond accreditation.
Mr. Van Winkle, you practice in this area of helping folks. Give me the range of the type of investor class you ultimately will represent or deal with or help.
The investors that we are typically working with, and usually we come across them because we're representing the businesses that are using their network. That's really their only method today, and they're going out and talking to their friends and other business acquaintances, and they're talking to people who are other business owners. Sometimes they're talking to family members. Many of them have been owners of some other business, so they have some sense of how to do that, or they've been just a person who's paid attention to things over the years. It's a wide range, but today it's a relatively small group because it's based upon personal connections. And so someone who might know about an idea has no idea how to go about investing in it. And I think that's what we're hoping to unlock, is that ability to create a connection, and then within the regulatory framework, enable them to make that investment lawfully.
You're actually just nailed where I was trying to go here. If my wife and I, on occasion, we find a product we absolutely love, and I assume other people have this experience saying, well, we have a little money saved up. Do we go out and buy a boat, or do we actually put some money someplace? Well, if you put it in a savings account or other things today, you get almost no yield in this world. But maybe I should take a little risk because I love organic. I live on your type of product. And you said, even though it's going to be the kids' version at Costco, I will look for it. But how do we take that next subclass of investor and make it more egalitarian so they can invest? Do you see us with the approach we're trying to hopefully get the SEC to move in the Jobs Act to provide those opportunities?
I think that's what the Title II is trying to do, and say that there are a lot of accredited investors who perhaps are suitable investors, and they are unable to connect with issuers. So they will be able to do that. The issuers will be able to announce, we're looking for investors, and it will go about, I think there will be new ways of communicating, and it will connect those folks.
But somewhere here, and this is not, this may be Jobs Act 3.0 eventually if we ever get to that, and I know I'm heading over time, but you're involved in a microlender. But ultimately, I would love to see a world where it's microequity, where I can take a few $100s or a few $1,000s, and I know for many folks that was a vision within the crowdfunding, and take a risk, but actually start to be someone who gets to participate in the rewards of taking that risk. So this is the end of this panel. Thank you for participating with us. For all of you, we'd love if you have any other ideas or suggestions how we can do this better. Please share that with us. We have a letter from the ICBA that will be put into the record, and without any objections, this committee is closed.